after the hearing today, we had your colleague making statements that the NDC is misleading the public with some statements they make, like what they made, that the judges seem to be on the side of the respondent. What's your sentiments on that?
Most importantly, I agree with my colleague 100% without any shred of doubt. The reason being that so far, if you look at all the interlocutory applications that the petitioner has brought before the court, anytime the court upholds any of those applications or give a favorable ruling, as it happened in the application for amendments of their petition, you realize that they are excited, and then they'll go ahead to say that the court did the right thing. But the moment the court dismisses an application, they come to tell the public that the court wasn't fair, the ruling is unthinkable, is scandalous. They use all manner of words on the court. And we believe that for the benefit of the public who may be watching the proceedings in court but may not understand due to some of the legal issues that are raised and the kind of language that are used in the courtroom, it is better to bring some clarity to this kind of matter. That you can come to court but proceed on the grounds that you are coming to make your case and not wait for your opponent to come and make your case for you. You proceed on the strength of your case and not the weakness on your opponent's case. So, assuming without admitting that your opponent, per strategy or any reason whatsoever, does not believe in responding by way of adducing evidence to support a case, that shouldn't be your business. Your business is to bring a compelling case before the court and adduce enough evidence to meet the kind of threshold that the court has set to rule in your favor. So I totally agree with my colleague. And you realize that most of the time, some of the issues that are brought up in the courtroom are not what they stand here and tell the people. And that is so unfair. You know, the court, in the ruling of the court made certain statements that, you know, we have something that you can take as accountability on the part of lawyers or counsel. They are professionals. As a party, you may not understand, you know, the magnitude of your case, the kind of evidence that is required. That is why you get the services of lawyers to assist you in prosecuting your case. Therefore, you would expect that at the time of hearing, the counsel for the petitioner will gather all relevant evidence, will get the most favorable witnesses, will get all the issues set down which will help their case. You won't expect that they will come to court and be given all the time to adduce evidence, all the time to file processes, and they will voluntarily tell the court that I have closed my case. At this point, I think I have made the case enough. It is enough to sustain me. Then the respondents say, okay, we are not even adducing evidence. It is not as if the respondents came and adduced some evidence to destroy the petitioner's case. The respondents did not adduce any evidence. In fact, they did not even bring in a witness statement that was one-to-one, or that you say evidence in chief and you did not get opportunity to cross-examine, because that would have been contrary to the Evidence Act. But this time around, they said, we are not even adducing any evidence because, in our opinion, the petitioner's case is weak on its own. We need not attack it. So the court should go ahead and give a ruling based on the petitioner's case, even if it is adverse to us. We think the petitioner has not met the threshold for us to even come in to punch further holes in the petitioner's case. And the petitioner is insisting that, as for the chairperson of the first respondent, we should put her in the box on the basis of accountability to the public. And for the public, that is so unfair. It's an unfair comment. The reason being that you came to court under Article 64, Clause 1 of the 1992 Constitution, challenging the validity of an election. You did not come to court because you were seeking accountability for the people of Ghana. So we cannot keep shifting the goalposts because what you are seeking to get from the court, you've not gotten. If you came to challenge the validity, adduce enough evidence that will settle any of the 5 issues that the court has set. That nobody got 50% plus, that the declaration was in contravention to Article 63, Clause 3 of the Constitution, that the Techima and South votes could have made a difference in terms of percentage. As a result, President Akufo-Addo couldn't have won by 50%. That there were alleged vote padding put together which could have affected the outcome of the election. But so far, my sister, look at the amount of evidence that they've adduced. None of these 5 issues that were set down to be determined have been exhausted by the kind of evidence that they've brought to court. But to say that I was sent by the EC chair, that I sat there 3 hours to drink tea, that she deceived me, that I signed in error, that I signed because I didn't want to be someone who will bring issues. They have given some of the most ridiculous excuses as to why they are here. But not once have they attempted to prove any of the issues that have been set down. So per law, if you can't compel someone to stand in the witness box, the court is saying that this is not an irregular case. Show us a law that states that the rules that apply to you and I or everybody shouldn't apply to the EC chair because she's a public officer. And then the petitioner's lawyers have failed to point out a single law, be it by statutes, the constitution, or case law. They haven't shown any law. But to say that it doesn't hurt appeal to conscience, and that if you are God-fearing, your conscience will set you free, you are in a court of law, for Christ's sake. And for legal practitioners at least, we should not follow the bandwagon and say, let's use some gimmicks to get public sympathy. It is our responsibility to apply the law properly and also to educate the public about those processes.